Hi. Yes.
My name is Michael Tolan, I'm the court reporter.
Okay. Not with me, but I can get, hold on. I'll just run and grab one. Oh, okay.
The address is Main Street, second floor. You don't need that. I'll just have your name. I'll just need your email address and phone number.
Okay. Just the first page is fine.
Yeah, you can write it. Those are all of the board members.
And what else do you need?
And then your state of Tennessee, Office of General Counsel,
Mhm.
address, second floor.
Yep.
All that stuff.
All that.
Thank you, Attorney Wood.
Of course, thank you.
Yeah, keeping that door closed, keeping it cold in here. Yes, yes.
I guess. You know what I need is. Yes, please. Mine should help. No, I need your phone number. I have your work one, your personal. It's in settings.
That's
and
a
it's
shame they
next to
can't-
it. Yep.
That's me.
Text you.
I didn't, I just found it because the purse is so small. I needed to put my keys.
I got you. There it is.
I like this little purse, but I think the one in this one.
Oh, no, it's good. I had that, had the- up the wall, it's not a page. Where's it at?
I don't know what they're
I
gonna
think that's
ask
two
me.
numbers I have. I'm not sure. the other one is. Oh, Kathy.
I've
And I
got,
had Peter. I did.
I've got Kristen.
I never have any. I mean, you talk about a cashless society. It's me. It's me.
You heard about that?
Yes.
That's what my parents wait.
Mhm.
Fantasies are.
Well, you know, they're starting to charge.
Does that mean you prefer Beth? Do you go with
Either.
Beth?
Or Elizabeth,
Out in the
either.
world, you prefer Beth?
My friends and family, yeah. Annika calls me Beth.
She's an old acquaintance, right?
I
An old
mean,
coworker?
yeah. in juvenile
Former
court.
coworker, way back when.
Is
Is there a bear? A bear? I dig it. It's an-
I think it's cool. I don't know, it's just the screensaver. It's the picture. I don't know, why the village with all the little lights in it.
And they couldn't just say,
It's a couple of bear. I mean,
Yeah,
we're coming.
You know what? I will be so glad when election
I don't
day's
know if you're gonna
over.
ask me for
I'm
it,
so
but
sick
I
of the
don't know.
commercials.
Me too.
She diverted here in Mississippi. And they suspended her license because that's her home state for immediate threat to public.
Mhm. Oh, yeah, there's no
drug
compromise at
violation or
all.
Other violation of drug statutes.
Everybody like new kids in
Mhm.
their own way.
So she was a bad kid.
Terrible.
All right, is everybody about
Even though they disagreed on privilege.
ready to go back on the record?
Decent to one another. I mean, they killed him. Oh, my God. It is crazy.
We're all set.
All right, we are back on the record now. It is August the 5th, 2026. We are here for the Board of Nursing hearings today. I believe we have just one more case on the docket today. That is the matter of Tennessee Department of Health versus Jelena Allen, docket number 17.19-262953A. All right, so I see that we have Ms. Woodard, is that the
Woodard.
right way to pronounce your name? Thank you,
Yes,
ma'am.
Your Honor.
Ms. Woodard here on behalf of the Department of Health. I do not see that anyone is here on behalf of the respondent, Jelena Allen. And on July the 23rd, 2026, one of my colleagues entered, actually the chief judge entered an order of default in this case. And so, Ms. Woodard, how would you like to proceed at this point?
Good afternoon, Your Honor and Board. Given the fact that Ms. Allen has had adequate notice under the statute and sufficient time to answer or appear and has declined to do so, I would ask that she be found in default. I do have a proposed order.
Yes, and actually, before we get to that, I do think that just to be sure, why don't you pass out the notice of hearing and charges if you have that? Let's make sure that none of the board members have any sort of a conflict or reason that they have to recuse themselves.
I knew there was a reason I printed all those off.
Okay. And I will state for the record while that's being passed out that as this morning, we have had a quorum here of the board and we have a more than 3-person panel available for this hearing. And so board members, as you review this, as with the prior cases, just think about whether or not you have any personal knowledge or any bias or prejudice that would prevent you from being impartial in this case. It's not an exhibit. And then board members, as you respond to whether or not you need to recuse yourself, we can do 2 things at once. You can also announce your name for the record, please.
James Darren McCoy, no conflict.
Thank you.
Charlotte Webb, no conflict.
Drew Malcolm, no conflict.
Samuel Austin, no conflict.
All right, very good. And so then I think, excuse me, we're not going to go over the technical record. There were no pending motions. Is that correct? Correct,
That
Ms.
is
Woodard?
correct, Your Honor.
All right, so go ahead with your motion then.
Thank you. I do have a proposed order that I would like to pass out to the board for their consideration as to the finding of fact and conclusions of law.
Well, why don't you make, excuse me, I'm sorry, my allergies. Why don't you go ahead and make your motion first? Then I can charge them with what they have to consider, and then you may pass that out, okay?
So the state would ask, state makes a motion to find the respondent, Jelena Allen, in default of the charges annotated in the notice of hearing and charges and memorandum for assessment of civil penalties.
All right, and I'm sorry, Ms. Woodard, were you done? I didn't mean to interrupt.
Yes.
Okay, all right, thank you. And so, board members, as I referenced, on July the 23rd, another administrative judge found that the respondent had been properly served, or at least reasonable efforts at service were made, and that the respondent was, let me see exactly what he said so that I'm telling you correctly. That the respondent was in default. The respondent was deemed to be in default and deemed to have admitted all the factual allegations in the notice of charges, waived the opportunity to show compliance with the law, waived the opportunity for a hearing on the notice of charges, and waived objection to any discipline requested in the notice of charges. And so with that, it is up to the board to determine whether you want to hold the respondent in default. And in making this determination, you will need to consider the statutory definition of default, and that is Tennessee Code annotated section 4-5-309A, which states that if a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case, the administrative judge or hearing officer hearing the case alone, or the agency, the board, sitting with the administrative judge, may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having due regard for the interest of justice and the orderly and prompt conduct of the proceedings. And so under that, you may either grant the motion to hold the respondent in default and have the state proceed with its proof, or you may deny the motion and continue the hearing. If you deny the motion, the case will be reset for hearing and the respondent will be re-notified. At this time, I will turn it over to the board to proceed with deliberations. And at this time, Ms. Woodard, please go ahead and pass out your proposed order.
Or is there any objection to anyone, to us moving forward and granting the motion to move in default? I'm in favor of granting the motion. We have to vote on that?
Yes, I think you, and also in addition to granting the motion, do you want the state to proceed with its proof in this case?
Yes,
Okay.
I would, all in favor of holding this respondent in default and moving forward this case in default, say aye.
Aye.
Aye. All opposed? So be it.
All right, thank you. And so then, Ms. Woodard, do you want to make an opening statement, or do you have proof that you'd like to put on, ma'am, to support the proposed discipline?
Yes, so, thank you, Your Honor. The respondent worked as a registered nurse at Methodist Labana Healthcare in Memphis. And during her employment there, on or about January 3rd, 2025, she was asked to submit to a probable cause urinary drug screen, and she refused. And then subsequently, during the investigation after that, Ms. Allen's Mississippi license, which is her home state license, was indefinitely suspended by the state of Mississippi on or about February 23rd, 2026, for being an immediate threat to the public and drug violation or other violation of drug statutes. So based on Ms. Allen's violation of the statute that 63-1-126 that requires a registered or a practical nurse to submit to a drug screen when requested, and also the Tennessee Comprehensive Rules and Regulations, wherein Ms. Allen's home state license was indefinitely suspended, making it impossible for her to practice in the state of Tennessee. We would ask that her privilege to practice in the state of Tennessee be revoked. And we would also ask for the imposition of type 3 civil penalties in the amount of $500 each for a total of $1,500. We'd ask to have those paid within 6 months. And we'd also ask to have the respondent pay the cost of this action with the assessment of cost not to exceed $15,000, also to be paid within 6 months of the issuance of assessment of costs.
All right, thank you, Ms. Woodard. Do you have any exhibits that you would like to submit? Do you have any certified records or other documentation that you'd want to submit to the board?
We don't, Your Honor, because all of the allegations in the notice of charges are deemed admitted.
All right, very good. Thank you, Ms. Woodard. Any closing statement?
No, Your
All
Honor.
right, thank you. All right, and so, board members, let me pull this correct thing up. Bear with me, please. All right. In prior hearings today, I have charged you fully regarding the law that applies in contested cases before the board. I will refer you back to those for full instructions and now simply remind you of a few key points. First is that the state has alleged that the respondent violated certain provisions of state statutes and rules. It's the state's burden to prove those allegations by a preponderance of the evidence, meaning the greater weight of evidence. If the evidence is balanced, then the fact has not been proven. The state has the burden of proof and the respondent does not have the burden of proving that she's innocent. The final order must contain findings of fact, conclusions of law, a decision regarding what disciplinary action, if any, shall be taken, and the policy reasons for your decision. In making the findings of fact, there has been no testimony or evidence, but as Ms. Woodard stated, the allegations in the notice of hearing and charges are deemed to have been admitted. When you make your conclusions of law, they should tie back to your findings of fact and show why you are making that conclusion. And the policy reasons should accompany your determination about why this is the discipline that you are selecting. Your deliberations must be in public, and I am available to assist if you need anything. Ms. Woodard, did the order that you distributed to the board members, did that address the entire case, not just the finding of default?
Yes, Your Honor.
All right, thank you. And so, board members, you already have a proposed order that you may review. And as with the other cases, this is just a guideline for you to go by. You don't have to adopt it. But if you find it to meet your expectations, then you certainly may. I turn this over to the chair.
Thank you, Judge. Board members, this would seem to be a rather simpler case than some we've looked at today. But if you've had time to read over findings of fact and want to make a motion about those, I'll feel free to make that known.
I move in the case of Jelena Allen, Mississippi RN license number 918914, to find the facts in the state's proposed order number 1 through 4 true as written.
Second.
Proper motion is second on the table. All in favor, say aye. Aye. All opposed, motion carries. And with regard to conclusions of the law, these tie back directly to the findings of fact in that respondent refused to submit to a drug test, which is a violation of TCA 63-1-126. It's unprofessional conduct by virtue of TCA 63-7-115, parentheses A, parentheses 1. And it's consistent with unprofessional conduct as defined in TC Comprehensive Rules and Regulations 1000-01-.08, parentheses 1. We have jurisdiction in the matter, being the Board of Nursing, and have found that those findings of fact were met. Is there a motion about conclusions of law?
Samuel Lawson in the matter of Jelena Allen, Mississippi RN 918914. I move that we approve the state's conclusion of law, number 5 through 7.
Second.
Proper motion is second on the table. All in favor, say aye.
Aye.
All opposed, motion carries. Now, the state's proposed discipline in this matter was to revoke her privilege to practice in Tennessee, which makes good sense since she was already disciplined by her home state, and to assess the 3 civil penalties, type C civil penalties totaling $1,500 to be paid within 6 months and total cost not to exceed $15,000 within 6 months. If that discipline seems rational to one of you, feel free to make a motion on that regard.
In the matter of Jaylene Allen, MSRN 918914, I move to accept the orders as written in 8, 9, and 10 submitted by the state.
Second.
Motion is second on the table. All in favor, say aye. Aye. All opposed? Motion carries. The reason for this decision is that the respondent's conduct enumerated in paragraphs 3 and 4 has been established by preponderance of evidence. Furthermore, respondent's conduct enumerated in paragraphs 4 is violative of the Nursing Practice Act and is of such a nature that the board takes this action in order to protect the health, safety, and welfare of the people in the state of Tennessee and to ensure the public's confidence in the nursing profession is preserved. Is there a motion to accept that reason for decision?
So moved.
Second. Motion is second on the table. All in favor, say aye. Aye. All opposed? Motion carries.
All right, thank you. Then, Ms. Woodard, I will look to you to get a final order signed by the board's chair and file that with the Administrative Procedures Division and circulate that to all the parties in the case. That final order shall contain detailed explanation of the appeal rights of the parties provided by the Tennessee Administrative Procedures Act. Are there any motions or any further matters that need to be taken before the board with my assistance today? Hearing none, we are adjourned for these hearings. Thank you. Yeah, I didn't get a chance to look at it. I didn't, so I just want to make sure it's got the right, some of these don't always have the right.